the study of company law is mainly based on these two principles. The first being the separate legal personality, the separate legal personality theory. And the second principle is the theory of limited liability. The theory of limited liability. These two principles will form the foundations of what we will mainly discuss hereafter as the concepts, the principles, the foundations of company law. So I would wish to start with the first one, which is the principle of separate legal personality. So what does this principle say? This principle is about the company being a separate entity, the company being recognized by law as being a separate person from its members. This is to say, if we had to have our company and our company as members, let's say 1, 2, 3, these would be persons with names. We can have Mark, James, and Jane, these being members of this company. The principle of separate legal personality suggests that our company is a different person in law from our Jane, James, and Smith, our 1, 2, 3, that these members of this company are recognized by law as being different entities from our company. This would further mean that our company, as created by law, has its own rights, will have its own obligations, which will be very different, which will be very distinct from the obligations of 1, 2, 3, who are the members of this company. That on the rights of 1, 2, 3, on the rights of the company, 1, 2, 3 cannot claim any benefit. On the obligations of this company, 1, 2, 3 may not be required to perform or to make good the obligations of this company. We have a very famous case that I would want to refer to, which establishes this principle of separate legal personality. This is the case of Salomon versus Salomon and Company Limited. Mr. Salomon was a leather merchant, and in his business as a leather merchant, he operated as a sole trader. But subsequently, he formed a company by the name Salomon and Company Limited. Now, to this company, he sold his leather business for some amount of money. But most interestingly, we had the membership of this company comprising of Salomon and the family. That the members of this company comprised of Mr. Salomon and his family members, the wife, the sons, and the daughter, were the members of this company, Salomon and Company Limited. Now, in part of the exchange, in the part of the transaction that is Salomon selling his business to the company, Salomon and Company Limited, he was paid by way of credit, where the outstanding amounts, he became a creditor, to this company, and a secured creditor for that matter. Now, the security given to Salomon was by way of a charge created on the assets of Salomon and Company Limited. So that if you are now to look at the relationship that became of Salomon and Company Limited, that first Salomon was a member of this company, and Salomon doubled as a creditor of this company. In respect of the purchase price of his business that he was not paid, Salomon became a creditor of this company, and in respect of the credit, Salomon was given security in all the assets of Salomon and Company Limited. Now, this company, Salomon and Company Limited, which now takes over the leather business of Salomon the merchant, went on to contract, of course, debt from other creditors. But at the end, this company was in financial problems and the company was to be wound up. Now, as you would later know, that in the process of winding up, when the assets of the company are realized, when the assets of the company are sold, we have the secured creditors being paid first before any other creditors of this company are paid. So the case as it would be, Salomon being the only secured creditor, all the assets of this company that were sold were applied to pay Salomon alone. And all the other creditors of this company did not get any payment from the sale of the assets of this company. Now, the issue was that these other creditors were complaining through the liquidator that Salomon, the owner of Salomon and Company Limited, had paid himself from the assets of Salomon and Company Limited that had been sold. So they went to court. This, as you see, Salomon versus Salomon and Company Limited is an appeal case. The first case was the liquidator of Salomon and Company Limited versus Salomon, the member. So that the issue was Salomon the same as Salomon and Company Limited due to the special relationship that Salomon has with the company, that he is a majority shareholder and all the members of the company happen to be his family members. So it was not until the appeal of this case lodged by Salomon himself at the House of Lords, where Lord McNaughton makes an observation that even though Salomon and the family are the only shareholders of this company, the company Salomon and Company Limited are different. That Salomon and the family and Salomon and Company Limited in law are different persons. The obligations of Salomon and Company Limited towards other creditors are not the obligation of Salomon, the member. So from the decision of the House of Lords, in this case Salomon and Company Limited, we get this groundbreaking principle that at law, the company is regarded as a separate legal person. That at law, the company is different from the subscribers to the memorandum. That the members and the company will be regarded in law as different persons. It is because of that principle that Salomon, the member of the company, is not to be responsible to the other creditors of this company, Salomon and Company Limited. The responsibility towards those other creditors is the responsibility of Salomon and Company Limited, the company, which is a different person from Salomon, the member of the company. So just to emphasize this point, irrespective of how much control a member has in a company, that member cannot be the company. You may own 100% of the shares in a company, but still you are not the company. The company will retain its own rights. The company will have its own obligations, which will not be the obligations of that member, which will not be the responsibilities of that individual member. So from this case, we now have this principle, the principle of separate legal personality, from which we shall henceforth regard the company as a separate legal entity. On to the second principle.